Hi, everybody, and welcome to today's solo webinar. Thank you so much for joining. We are really excited to welcome a special guest, attorney John Skiba, who is going to be sharing some tips and tricks on how to settle debt with a debt collector like Unifin. So thanks everyone again for joining. We're excited to have you all here. And if you are watching, please go ahead and start submitting your questions in the chat. We have Yale Levy, who's an attorney who works at Solo Suit, who can respond in the chat. I'll also be responding and dropping some helpful links and resources in the chat. But yes, go ahead, start submitting your questions. And soon we're going to get diving into those live questions here. But before we do, I just wanted to give some time to John to introduce yourself. John Skiba, can you tell us who you are and what you do, please?
Yeah, no, I'm glad to be here, Hannah. And I've been here a handful of times. So I'm always happy to be on the webinar here with Solo Suit. So yeah, my name is John Skiba. I'm an attorney. I own the Arizona Consumer Law Group in Arizona. So I'm in the Phoenix metro area. And I help people mostly with bankruptcy, Chapter 7, Chapter 13s. And then a big part of my practice is defending debt collection lawsuits, particularly those brought by junk debt buyers, you know, the portfolio recoveries, the Midlands, the LVNV, all those kind of companies. So I do a lot of that. And I do a lot of videos. I think that's how we initially met. As I do a YouTube channel called Consumer Warrior, where I talk about these same kind of things. So that's kind of me and what I do day to day.
Yeah, and John has, I think you have, 20 years of experience doing this type of work? Is that right?
22 years. I've been coming here every single day doing this for 22 years.
22 years. And so John really knows his stuff when it comes to working with debt collectors and getting lawsuits settled if you've been sued by a debt collector. I'm going to go ahead and drop his YouTube channel here in the chat for anyone who's interested. You can check out some of his work as well. But with that, we're going to go ahead and jump into some questions already. John, I wanted to ask you to answer a few questions about Unifin, since that's today's topic. And before we do that, I wanted to give a quick disclosure that although John is a licensed attorney, he is not your attorney. The information in this webinar is not legal advice, but it is legal resources that you can use to help you in your debt resolution journey. And even though we're talking specifically about Unifin today, generally the principles will apply to any debt collector that may be suing you or contacting you about a debt. So with that being said, John, can you tell us a little bit about what is Unifin?
Yeah, no, sure. So Unifin is a third-party debt collector. And it's important to kind of understand this. I see this a lot with my clients here in Arizona a lot. There's a lot of confusion as far as who all these players are. And it really matters because it tells you kind of where the case is at as far as the debt collection process. It tells you what your rights are under something called the Fair Debt Collection Practices Act. And it will tell you often if you're going to get sued by whoever it is who's contacting you. So like Unifin is a debt collector. Companies use them as they'll if their account goes delinquent, they can send out the account to Unifin. They'll do collections. They're the ones who are blowing up your phone, texting, emailing, just sending the snotty letters, everything like that you get. They typically are not a debt buyer. Now, the difference is a debt collector like Unifin is going to be the one who are just calling, trying to get you to pay. They're getting paid a fee to do that, and then it'll, but the money you pay, most of it's going to go back to whoever the creditor is, whoever holds the loan at that point, they'll receive the money. That's different than a debt buyer, like we talked about, like Portfolio Recovery, LVNB, Encore, all these companies. They actually purchase debt at a big discount. They're the ones who typically sue on it. You're not going to get sued by Unifin. You're going to get sued by maybe the creditor who hired Unifin to do the collection. You're just going to get annoyed and all that kind of stuff. It's also important because, like I mentioned, the Fair Debt Collection Practices Act, the FDCPA, that's applicable to debt collectors like Unifin. And so if they're violating that, and it's kind of beyond the scope of what we're going here, but if they're violating that, if they're saying things that aren't true, harassing you with calls at the wrong hours at the night and day kind of thing, then you may have some recourse against them. But kind of big view, that's what Unifin is. and they're somewhat different than a lot of the debt buyers that some people deal with when it comes to like lawsuits.
Thank you for clarifying. So Unifin is a debt collector. They're a third-party debt collection agency. So a bank or a credit card company may hire Unifin to collect for them. So if you're contacted by Unifin, you might be like, who is this? I've never borrowed any money from Unifin. Well, it's because they've been hired by someone that maybe you did borrow money from to collect debt for them. And like John said, Unifin probably won't be the one suing you, but they may try to collect debt very, very persistently before maybe legal action is taken. Next question for you, John, is, so I know that you typically deal with like legal negotiations, right? But what do you think, do you have any advice on what you could say to a Unifin debt collector to settle your debt for less? So this would be like before a lawsuit is filed. What do you think are some things you could say to a Unifin debt collector to settle?
One of the first things, no matter whether it's Unifin or anybody else, frankly, I always say, go to them and say, where are they at? What would it take to get this resolved? Because often they have some built-in pre-authorized settlement authority as far as what they're willing to do. And that'll let you know kind of, if you're in the ballpark or not. But I always say, come with a plan. If you're going to call them or if you're going to pick up their call or respond to their text, finding out what they're willing to accept, but then having a plan as far as what you could realistically do. I always say, at the end of the day, companies like Unifin, they want to collect money from you. And if you're willing to offer something, there's got to be some middle ground that can be reached. I really, a lot of times what I focus on is the information I would not give them. I would not give them information where you bank, where you're employed, things like that. At this stage, those things are not relevant. But what you can share with them are things like saying, hey, here's what I can do. Here's my proposal. Here's what I can pay. Here's when I can pay it. And then I think providing some information and background on hardship that you're dealing with is important. I often, particularly as an attorney, I view my job is to help the other side essentially sell this lower amount to their client. And so Unifin, if they get information that, look, this person's on Social Security, they receive disability, there's been a job loss, death in the family, medical issues, you don't need to provide, your whole medical history or anything, but if there's things like that that can influence that, they do that can influence the amount that they're willing to take, that they'll take a lower amount. And often they may even have programs or pre-authorized things where, like you were saying, if there's a hardship, if there's been a death in the family, job loss, where they may be willing to take considerably less even than what their first offer is.
That's great advice. So I think the key here is to just communicate, like be open to communicating. Ignoring debt collectors isn't going to make the debt go away. Yes, they can be kind of intimidating, and some can get very persistent. But usually many debt collectors will work with you to find a solution, especially like John said, if you are experiencing hardship, you have obstacles in your life that are making it hard for you to pay your bills. Just be open and communicate. The key is to just talk. Don't ignore them.
And can I tell you one thing? And this is kind of just anecdotal, but something, because I think you touched on a good point there, that it can be intimidating to reach out to these people because, we feel like, I wasn't able to pay this. We're stressed. We might be embarrassed, not sure what to say, what not to say. I can tell you the people I have had a ton of clients who are debt collectors. And what it always tells me is, look, we're all kind of in the same boat here. We all have different jobs, but they know what you're going through. I mean, truthfully, they do. A lot of them are experiencing the same thing personally. And I'm not saying, obviously across the board. I'm just saying you'd be surprised how many bankruptcies and things like that I have filed for people who tell me, oh yeah, I'm a debt collector for a so-and-so company. So I think if you kind of go into it with that mindset of, look, this person, they're just doing their job. They probably know exactly what I'm going through. Let's just see if we can get something put together. Just talk person to person of how you can get something done. And I think communication is the key. Whether it's debt collection lawsuits, debt collection like this, to me, the worst thing you can do is just try to ignore it. It's not going to get better. It's not going to go away, especially now. Maybe 20 years ago when I started doing this, things would go away. You don't see that as much anymore. It just gets sold and sold and sold, and they still keep coming after you.
Yeah, and to that point, most debt collectors, they're human beings. They're just like you. And well, all debt collection agencies are required to train their employees on how to treat borrowers respectfully when they try to collect debt from them. And there are federal laws that protect people who are experiencing collections from being treated unfairly. And so Unifin does train its collectors to be decent people when they're dealing with borrowers and trying to collect debt. But that doesn't mean that there's never any rogue debt collectors. So luckily, Fair Debt Collection Practices Act does protect you, and you have rights if you are a consumer dealing with debt collectors. I will go ahead and drop a link in the chat here in just a minute about the FDCPA and how it can protect your rights. But with that being said, I just wanted to jump to one last question, John, before we open it up to the live chat for questions. And that question is, how can you know if a Unifin debt collector is a scam? So just to preface that, Unifin debt collectors are real. Unifin is a real, legit collection agency, but there are a lot of debt collection scams out there that are, not connected to Unifin at all. So how can you know if a Unifin debt collector is a scam?
Yeah, it's a good question, especially now where there's a lot of text message communication, and even just today, I got an email that said it was, my Amazon logged in, but when I looked at the return email, it was not an Amazon thing. So it's something where if you're unsure, particularly if it's email or a phone call, you can ask for verification. I know over at SoloSuit's website, you have validation letters that you can send out, where if you send that out, it does a couple things. One, they have to stop collection until they fulfill that. And so if you're worried about it being, escalated to a lawsuit or additional phone calls and all that kind of stuff, you can send the letter. And to me, something like what SoloSuit does is very helpful, because too many people don't do this step because they get caught up in, I've got to have the legalese and all that in there. It's a pretty basic thing that just sends out and says, look, you need to verify this debt. Tell me exactly who you are. Legitimate collectors and debt collection agencies will respond to this. They're governed by the FDCPA and all these other regulations. They're not just going to blow that off. If they do blow it off, that's a sign to you that maybe this wasn't somebody legitimate, but maybe just some rogue out there. And they are. They're you see it all the time. So if it's something you have any concerns at all, it's something where I would send the validation letter.
Yeah, that's a great way, I think, to one, validate a debt if you're unsure that you actually owe it, but it's also a great way to avoid scammers. So be careful out there, y'all. Well, cool. Well, any other last words on just how to settle a debt, even if it's before a lawsuit has been filed?
I think that you need to communicate, go in with a plan, but I also say be careful. Don't commit yourself to something you can't do. Don't commit to a lump sum or some kind of payment plan that is just destined to fail. You got to be willing to walk away, because even if something gets escalated to a lawsuit, you can still deal with it. Frankly, sometimes I see better deals when the lawsuits get filed. Not always, but a lot of times, just finding out what it is that they're willing to do. Every now and again, I see letters come from debt collectors, and I'm shocked at how good the deal is. That there's something that they're seeing in their algorithm and the way that they're viewing you and your situation, that they're willing to come in with a lower deal. But be willing to walk away from the settlement if it's something you don't feel comfortable entering into. There's always tomorrow. You can call back, and see if you can get something done at that point. But don't commit to something that that you're not going to be able to do. That will make the situation more difficult.
Great. I love that. Yeah. Don't commit to making a payment if it's going to be more difficult in your future to do that and fulfill your end of the agreement. Great. Yeah. Well, John, thanks for those answers. And I think it's a good time now we can jump into some live questions that we've received from real solo users and viewers. So we'll go ahead and get started with a question from Rick. It says, okay. Hi, I received a summons on December 22nd, 2024. I filed my response with the court and mailed it to the attorney. I also filed a solo settlement 2 weeks ago. No response. Next, should I call the attorney direct to offer a settlement? So John, Before I turn that question over to you, I just wanted to say it sounds like you've used Solo Settle to send an offer to try to settle the debt. Some law firms will respond to those offers, and others, are still getting on board with responding. So I just wanted to be transparent there and say, if you haven't heard back from them, you may want to take further steps to try to negotiate. But yes, John, can you tell us, like, if someone has been sued for debt and they filed their answer and then it just goes silent, like, what would be a good thing for them to do if they're trying to resolve it? Should they call the attorney directly? Who should they talk to?
Yeah, and it's a common thing because most debt collection law firms, relative to the number of cases they're filing, they have few attorneys. Here in the Phoenix area, even the biggest collection law firms have, 5 or 6 attorneys, and they're filing thousands of cases a year, which is gigantic. Most lawyers have under 100 cases. They're dealing with giant volume. And so they may not be, reaching out to you on a daily basis or anything, or at all, like, that this person's dealing with. I don't think there's any harm, particularly once a lawsuit's been filed, in reaching out just to see where they're at. There's a rule of evidence, Rule 408 in most jurisdictions, and it allows the parties to talk. So it basically says that settlement discussions are not admissible in the case against you. And that's because the courts want the parties to talk. They want them to try to resolve it. That frees up judicial resources, makes you get done with the case sooner. You're not at risk of getting like an attorney's fee award against you if it goes to like a trial or something like that. So yeah, I would reach out. I can tell you, I've seen with a lot of my clients, with a lot of the debt collection firms, because they have such huge volume, it's tough to reach through and get hold of the attorney. And the attorney is usually the final decider, on cases as far as whether they're going to be settled. Often you get their paralegals or debt collection people when you call in. If you look at the documents, though, that are filed with the court, in a lot of jurisdictions, they require the attorneys to put their email address in the upper right-hand corner. That might be a way. I get way better responses when I email debt collectors or the attorneys who are representing rather than phone calls. So that may be a couple ways to, but yeah, I don't think there's any harm at all in reaching out and just kind of seeing where they're at. And if they're open to a proposal, what they're willing to do, that kind of thing.
Great. So it sounds like it's best to if you've been sued, to reach out directly to the attorney. You can find their information on the court documents you received. Oftentimes you'll see an email address that could be a good way to communicate with them. And, you can also use Solo Settle to send an offer to debt collection attorneys to try to negotiate online and move the process away from the phones, away from the courtroom, and digital. So yeah, that's great advice. Let's see. I've got another question on here from Jesse. It says, what about a company like Midland? Should you accept the initial settlement offer with them or wait to be served? The judge in my county always sends suit to online settlement tools. So I'm not sure what the last bit of that means, but it sounds like, Jesse, you may have been contacted by Midland Funding. He's asking, should I accept the initial settlement offer with them or wait to be served?
If the offer is something you feel comfortable with and can do, I don't see any downside to it. I often tell clients here in my practice in Arizona that you kind of have to define, what a win is for you. And, settling a case, and most cases do settle. If it's something that you feel, okay, we can do this is realistic, there's also a huge benefit to getting it out of your life. Lawsuits, particularly if you're representing yourself, it's going to take over your life, 100%. I talk to people all the time. They spend all night researching, trying to figure out, am I using the right paper? Am I saying the right things? Am I saying, putting the right statutes in and all that kind of stuff? There's some benefit to getting it over soon. And again, even like I said, there's no harm in at least seeing where they're at. Sometimes I do see settlement offers get better when the lawsuits are filed, but I've also seen them get worse. And so it's really kind of a personal thing for each person. If you're getting sued for $5,000 and they come in and say, hey, we'll take $2,000 to get this thing to go away, if that may be worth your time and effort and peace of mind just to get the thing done. So it's individual. I don't see there's any big benefit to waiting to get sued or to get served, because at a minimum, you're going to have to file an answer. There's a filing fee involved with that. There's going to be some additional costs that you're not going to experience if you just get it settled now.
Yeah, so it sounds like it's best to just try to get things resolved like quicker down the line instead of waiting, because the longer you wait, the more interest that can accrue, the more attorney costs, legal fees that could pile up, and then you end up having to pay more than maybe the original debt amount was. So it sounds like it might be a good idea to accept the initial offer, but I would agree with John. There's just so many factors that play into it. And you can test out negotiating to see if they would budge a little bit, especially if you can explain where you're at, why you're missing your payments. Midland even will work with you. Okay, let's see. Next question is from Jamie. It says, I asked for verification and I received detailed statements. I was told that this is a valid debt. I am supposed to provide evidence of if I believe I have hardship. What should I do next?
Yeah, and that's pretty standard as far as them verifying the debt. There's no real clear-cut standard as far as what the FDCPA requires, other than they just provide you something showing that the debt's legitimate, that they're the owner of it. As far, if they're asking for hardship, and I guess it depends on what the hardship is. And sometimes it can be just as simple as a statement. Often, if I have a client that's only on Social Security, whether it's retirement or disability, I'll often send the award letter that, every January, that it'll show if there's been a cost of living increase or whatever, because it shows what the amount is. I provide things like that. If there's medical issues and stuff like that, I don't recommend providing your medical, documents to them or anything like that. But you may ask them specifically what they're looking for based upon what your hardship is. Because that's kind of a difficult one. If you've lost your job, it's kind of hard to prove a negative, prove you don't have a job kind of thing. So I would turn that one around on the collector, just saying, look, here's what my problem is. What are you guys looking for? Because there's probably something that they have in their procedures where they want to check the box as far as, okay, we have what we need here.
Yeah, so you can ask them, what exactly is it that you need to be able to prove hardship? Yeah. All right, let's see. So we have another question from someone named Aaron. It says, I registered my debt 2 years ago with a debt relief company. They didn't resolve the debt, and I got sued in Indiana. I filed the answer with Solo. Now what do I do? And then it says, the original debt was $6,700. They are suing me for $10,000. And then, one other comment. It says, they are not negotiating with the debt relief company. What do I do?
Yeah. And, I see this, frankly, a lot with kind of debt relief company situations. They're effective, in my experience, if you have relatively few debts and something you can probably get settled pretty quickly. When you have a lot of different accounts, I see people who come in with 15 credit cards, and if the debt relief company gets half of them resolved, but then you get sued by the other half, then you're kind of in the same spot. It's something where if you filed your answer, and you're gonna have to kind of do some research on this as far as what the procedures are in your particular state. In most jurisdictions, the next step is the parties have to exchange what are called initial disclosures. This is where the parties essentially show their cards. There's no trial by ambush. The parties have to show documents, potential witnesses, and as a consumer, you have to do that as well. You have to provide any information, any documents, any correspondence, basically so both sides can look and see everything that's actually, going on and kind of evaluate the case better. Like often when I file an answer for a client, I usually don't do a whole lot of settlement discussions until I get their disclosure, so I can see how strong or weak the case is, and that impacts how we're going to approach settlement. So that would be my recommendation, is look in the rules of civil procedure for your particular court. Google Scholar can be a good resource for looking up stuff like that. And go there and see what the rules are. It'd probably be Rule 26 in most jurisdictions. And it will tell you when the disclosure's due. And that can be kind of tricky too. Like in Arizona, our justice courts, it's due 40 days after the answer, but our superior courts is due 30. I don't know why it's not uniform, but it's not. And so you want to look that up and see what the next step is. Sometimes you can call the clerk of the court. They can't give you legal advice, but sometimes you can say, hey, are there any forms? And then they'll have a packet that'll show you kind of what the next steps are.
Great. So yeah, it sounds like you have a lot of options. But I think, again, just reiterating what we've said before, like the key is to communicate, be proactive, don't wait for a solution. Like you've got to kind of find your solutions and make something happen. And open communication can often lead to the ideal outcome, not just for you, but also for the debt collector. So let's see. We've got another question going back to the question about hardship. Jamie had a follow-up question. She said, is evicting a tenant considered a valid hardship? So it sounds like maybe, Jamie, you're experiencing eviction. John, would eviction be considered a valid hardship for a debt collector?
Yes. And probably even more, what's the underlying cause of the eviction? Is it something, job loss, income reduction, divorce, things like that I may bring up. And I think it's important. It's not a bad thing to say, hey, look, I have this eviction pending. Part of it too is you've got to see that from the debt collector's point of view, they want to go and use their time and resources on places where they know they're going to be able to collect. If you're and that's why I bring up Social Security, they can't garnish it. And so they know it's going to be difficult for them to collect. And so sometimes like explaining that will get you a better deal, or sometimes even they'll just walk away from it. Eviction may do the same thing. I will often, I've had clients come to me and they say, look, I have 5 different lawsuits in our local justice court system here. I will reach out to the creditor and say, look, here's what the offer is. And the hardship is they've got 4 other lawsuits behind you. So you can, first come, first serve. You can take this and be done with it, or we're going to move on to the next one. The fact of intense collection activity can be a hardship in its own right. And so letting them know, hey, look, I just got evicted, or I'm facing this eviction lawsuit. I've got to put some resources here so I have a place for me and my family to live. I don't have anything right now, or here's a minimal amount I can do and then be done with it. I think that would be appropriate. And they may require you to show like the eviction, the case number. I always do that when I'm negotiating and there's a lot of lawsuits. I actually put the case number in there so that the other side knows that I'm not just, bluffing on this, but there's actual litigation going on.
Okay, so John, while you were giving that answer, which was really great, Jamie came back in the chat and gave us more information about her situation. Or about their situation. It says here, so they were asking, is evicting a tenant considered a valid hardship? I am the landlord. It's for non-payment, so I'm having to pay my mortgage and for the place that I'm living in. So it sounds like Jamie's in the middle of evicting someone from their own property, and it's making it hard for them to keep up with their bills. So yeah, do you have any advice on that? Like, do you think going through that process could maybe be a good reason for a debt collector to settle for less?
So they're having a problem then with the mortgage company because they're not getting the rental amounts. Am I understanding it correctly?
Yeah, Jamie says I am the landlord. I'm paying for my mortgage and the place that I'm currently living in, and I'm in the middle of evicting a tenant. Would that be considered valid hardship?
As far as like if Jamie's saying, okay, I can't pay my mortgage on this property, secured debt is a different beast altogether. If you're dealing with mortgages, car loans, anything with collateral, they may have programs, particularly if it's your personal residence. I always say reach out, and they have a loss mitigation department in all mortgage lenders. And you can talk to their loss mitigation department and say, look, I've got this situation. What can you do to help me out here? So yes, I would share that, hey, I'm not making the payment because I've got this tenant. And sometimes they have programs where they're willing to adjust the payments, maybe do like kind of moratorium on a payment. It's important to know with secured debt, car loans, mortgages, if you don't pay, they can be aggressive. They can repossess, they can start the foreclosure process. So that's something you want to be communicating a lot, because they're not just a credit card company that's going to call you and annoy you and, send you off to a debt collection company. They're going to take things. And so they're the ones I always recommend. That being said, particularly mortgage lenders, and particularly if it's your personal residence, they're going to have something that can be done to help you to avoid a foreclosure. And so I would reach out to them and communicate frequently with them on those kind of things.
Great. That actually leads to the very last question we have, which is being sued by Amex, American Express. Can they go after the equity in my house? So this is kind of related. What would you say?
Yeah, American Express is one of the more aggressive credit card companies. They don't sell their debt, and they usually sue within about like a year, which is fast for most creditors. So before they sue you, they can't go after the equity in your house. But what that's a reason why they sue, because they want to garnish your wages, garnish your bank accounts, and record it with the county recorder, and then it acts as a lien against any real estate that you have in that county. And so that's how they could technically go after the equity. It gets a little bit more complicated than that because most states have a homestead exemption. And so, for example, here in Arizona, the homestead exemption protects up to $425,000 of equity. So if I had a first mortgage on my house and then they come in, Amex does and records a lien against my home, the only way they could really sell the house and foreclose on it is if they paid off the first mortgage, gave me my full $425,000 of equity, and then if there's anything left over, they would get some money. That's going to vary from state to state. The exemptions, I was on a continuing education call today. Can't remember which state it was, but they don't have any homestead. But like Florida, Texas, they have unlimited homestead. I think Oklahoma even has unlimited homestead exemption. Nevada is like 600,000, but I have like Kentucky was like 20,000. So that's something you need to talk to probably an attorney specifically if you want to defend the American Express. American Express, I do find they're aggressive, but they give pretty favorable settlement terms. I mean, I've done payment plans literally 8 years long. Not that you want to be in that, but that was a gigantic credit card that we were able to settle out. And I was surprised that they have more flexibility than a lot of credit card companies. So avoiding the judgment is going to be the best situation. But even if they get a judgment, they can lien your house, but they probably can't take your house if you're within the homestead exemption limits.
Wow, that's very helpful information. Hopefully the content within this webinar maybe answered some of your questions about debt. I think that's going to be our last question for the night because we're past time. But thank you all for joining and for watching. I'm going to drop a couple of links here in the chat right now. If you have been sued by a debt collector and you want to respond to the lawsuit, which is probably the best step to take to avoid a default judgment, you can actually use Solo to draft and file an answer to the lawsuit. And if you want to try to settle the debt, you can also use Solo Settle, one of our tools, to negotiate with debt collectors and debt attorneys online and move the whole negotiation process online to our settlement portal, where you can settle the debt before your court date and get everything documented. And you can even make your payments through our portal so that you keep your own financial information private and secure. So I'm going to go ahead and drop a link in the chat right now where you can where you can start that process through Solo. Let's see. And then if you've been sued in Arizona, I'm going to go ahead and drop a link to John's website. Let's see. Here we go. All right. I just dropped that in the chat as well. And yes, if anyone has any other questions about how to settle their debt, you can reach out to us at SoloSuit. Send us an email at support@solosuit.com. And we will get back to you and try to help you get on your path to debt resolution. Join our webinar every Wednesday where we have special guests like John frequently to answer your questions about debt. John, thank you again for joining. Any last words before we sign off?
No, appreciate the opportunity. And my parting advice is always communicate, keep that communication open, and you'll get through this.
Awesome. Well, thanks again, John. You're great. Great answers to some great questions tonight. Thanks everyone for watching, and good luck with